the technical gremlins are pretty much part of every courthouse, every courtroom, and every lawyer has to deal with it. And now he has this. There's a good chance he's not going to get this thing to work, because we've seen it happen a lot. Bottom line is, he's doing a good job, right? But it's not as good a job as the public defender would have done, is what the only argument I'd make. Oh, you're on mute, Michael.
I'm sorry, Ted.
No problem.
I apologize. Yeah, I was on mute. Here's my opinion, right? There are some terrible public defenders. Is it possible to defend yourself in a trial better than a public defender? I mean, there's pros and cons, right? You bring the passion and the emotion and the understanding of the facts better than any public defender would. But at the same time, you're biased. You're not going to see things like an objective person. Like if somebody were to get through to this person, they would convince him to not do a lot of the things he's doing, right? Some of the things he's doing are well. Marie Pereira brought up an example of something that he did that was well, right? In my opinion, what's the purpose of a trial? The purpose of a trial, if you're a defendant, is to get an acquittal. It's not to expose bad things in the prosecution and then get convicted. You're just delaying your conviction by an hour, right? The purpose is to get an acquittal. So I think he's doing a serviceable job, but I think a public defender would have done a better job. And the evidence of that is that he fired his attorney. He fired his attorney and wouldn't take another one. I've seen this too many times, and it always comes down to the same point. The defendant is not listening to reason. And he said in his letter to the judge, I don't want to take a plea, right? That means they offered him a plea. This is a person where an objective observer would have told him, look, you need to take a plea here, right? I've had many instances where I would line up a really good plea. Most people don't go to trial. Most of these criminal cases, they settle in a plea because the evidence is overwhelming, and you have to overcome a mountain of evidence against you, and the state has been preparing for the case longer than you've been preparing for your defense, right? That doesn't make it right. That's just the way it is.
His plea is time served. I mean, he would have been, he said no to it. And on some level, you're like, all right, well, I guess this guy's doesn't want to be, convicted of something he didn't do.
Yeah, but a public defender would have been able to talk reason into this person, or been able to handle the trial in a better way, because he could have had these same defenses if he had a public defender. It's not like the public defender would have told him, no, this is a good line of inquiry, but I'm not going to do it. The public defender would have done it. And it's a little bit disorienting as well to see a person defend themselves. It's actually, this is the positive side of defending yourself. People see you're sophisticated, you're out there, you're fighting for yourself. But there's going to come a point in this case where there's going to be eyewitness testimony of people that are credible, that saw him, that point him to the scene of the crime. And I just don't see how he's going to do that. What's he going to do? Come back and say, well, why didn't they look at this other lady? That's really his defense, and that's not really a defense. That's a defense if nobody can point a finger to you doing the crime. That's a great defense. They teach us that in first-year law school, right? If there's nothing that
have. I mean, there is a witness that's going to say that it wasn't him, who is great for him. I mean, he's got a case. There's no doubt about it.